I wish I could tell you that the work of the Fair Housing Center, which started in 1977, the center itself, to give you some history since we're dealing with history, after 1967, the riots that occurred here in the city of Detroit, people came from all over the country to try to strategize on how they could help the city to resolve the problems that people perceived led up to the riots. If some people might not remember, some might not be old enough to remember, how did the riots start? Well, they started because the police raided a blind pig on 12th Street, and some violence broke out, but during that time there was a lot of stop and frisk, there was a lot of police brutality, there was a lot of unemployment, there was a lot of civil unrest under the threshold. And if it sounds just like 2015, it's because it was. So what is old is new again, and that was how the center began, because these people came from all over the country and they strategized and they said, you know, we need to address this problem, and we're going to form an organization, New Detroit, to address this problem, and we need to form another organization to address this other problem. And as they were packing up their suitcases and ready to go back to their home states, they said, wait a minute, we haven't addressed the issue of housing. So they unpacked and they started to strategize again, and after a while they decided to start the Fair Housing Center of Metropolitan Detroit, which was the Fair Housing Center of Detroit at that time. Later on, the name was changed to Metropolitan Detroit because our service area is Wayne, Oakland, and Macomb County. And the only reason for this organization to be created was to deal with housing discrimination. Doesn't do anything else. They felt that all the other organizations that had been created or strengthened, as it will, the NAACP certainly was already here, but they wanted to give it some new life. Urban League was certainly already here. They wanted to give it new life, but they felt that there was no organization that had its sole purpose to deal with housing discrimination. So the Housing Center began, and it has served many roles. Some of you have heard me before. You know that we do enforcement. We use testers who are trained, paid actors who pose as home seekers, and we send them out on missions. We give them a profile and we tell them to go out and pretend that they're interested in buying a house or renting a house, and they make a report back to us as to what they see, observe, what was said to them, and then based on that we decide whether or not there is any evidence of housing discrimination.
Now, do you see more discrimination in rental, or people looking to buy a home?
We see more discrimination in terms of rental, but I'm not so sure it's because there is more of it, is more so than more people bring it to our attention. There is a lot of discrimination still in lending. There's a lot of discrimination still in people who are willing to even put their house on the market. We have had recently, give you an example, a woman was in the military and she is from Detroit. She was finishing her deployment and she wanted to move back to the Detroit area. So she asked her mother and her sister to get a realtor and start looking for housing. This is last year. Looking for housing that the three of them would share. So they got a realtor and they started looking around, and they came across a house in Westland that they were shown. The house was empty. But when they were entered the house, they found that someone had painted on the wall, "No niggers allowed. Stay home." This is last year. So 2014. So they liked the house, but for the graffiti that was painted on the wall, and they took pictures as they had been doing all along. As they saw a house, they would take pictures, anything that wasn't already on the website, they would take pictures and send it back to their daughter, sister, and they showed it to her, and she liked the layout in terms of what they needed, but of course she wasn't happy with the idea that this was on the wall. And she asked them to go back and take some more pictures, but as they were leaving, they also asked the realtor to have this removed. They came back a month later and it was still there. So the realtor, who had a responsibility to notify whoever the company that owned it to do something about that, had done nothing. And still, because they hadn't done anything, they had no reason to expect that anything had been done, they went and showed it and it was still there. So of course they're a little nervous about the idea of buying this house or putting in an offer when whoever lives nearby, who has access to it, has written this kind of thing. So that particular complaint came to us in the form of a complaint. It's a little hard to test that kind of thing, other than to send more people pretending to be interested in buying it to see. But we already had the pictures, so it really didn't need to be tested.
So who would you bring, in that situation, who would you bring enforcement action against? Would it be the homeowner? Don't they have a right to sell the property to whomever they want?
Oh, no, they don't. No, they don't have a right to sell it to whomever they want. The Fair Housing Amendments Act, which what I wanted to, since the history is sort of the theme for this evening, one of our strongest supporters is Professor Otto Hutzel, and Professor Hutzel was asked by HUD to commemorate the 50th anniversary of HUD to write his reflections about how the Fair Housing Amendments Act, which was passed in 1968, how it was created. And so he created a paper, and he was kind enough to let me share it with you. Very few people have actually seen it. It's in your packet, which if you haven't picked up a packet, yes, in the blue folders.
Thank you.
And what he did, because he was one of the attorneys assigned to write the law, he talks about all the politics that went on behind the scenes to try to get this law passed. The law actually was created as a concept about 4 or 5 years before it was actually passed. It failed in Congress, as did many other attempts to pass civil rights legislation until 1968, because what happened in 1968? Martin Luther King was assassinated, and when he was assassinated, this law that had been rolling around in Congress for a period of years was passed within 7 days. But one of the reasons that it was able to get passed in 7 days is because it's already written. They didn't have to write the law in 7 days. It was written. They had been debating and trying to get it moved through committees for a period of time. They had added amendments, taken amendments out, negotiated behind the scenes. So although the impetus for having it signed came on the backs of a man dying, the law itself was not something that was newly created at that point in time. So I find the history, for me, interesting. But one of the things that he talks about, in addition to all the politicking and committees and the dickering and dealing about what could and could not go into the law, and the Southern Democrats, what they were willing to do and what they weren't willing to do, they had to get a coalition of people, Republicans, Democrats, Independents, to sign on to this, and so they had to add things and subtract things. But some of the things that he discussed in how this law got passed was the fact that the federal government had been instrumental in supporting segregation. And so HUD had been designated as the lead agency that was going to champion this law and was going to enforce this law, when in fact HUD and FHA had been one of the lead agencies in enforcing segregation throughout the country since, when was the first fair housing law written? 1866, right after the Civil War. Congress passed the first fair housing law, and it protected the newly freed black male slaves, because women didn't get any rights until the 1920s. But the law didn't say women, it said these rights to rent, buy, sell, lease, convey property would be given to all persons, giving them the same rights as white citizens. So that was the law then. That law has never been overturned. So no, you do not have the right to deny housing to people of African American descent, because in 1866 this country says that was illegal, and that law has never changed.
So it has nothing to do with whether or not there's a private owner or public funds.
That
going in
law
across the
applies
board.
to everyone. The Fair Housing Amendments Act that was passed in 1968 does carve out what they call the mom and pop exception. That says if you are owner of 4 or fewer units, particularly if it's owner occupied, there are certain aspects of the law that don't apply to you. But it doesn't talk about race. Never has. So no, you don't have the right to discriminate based on race, because in 1866, this country says you couldn't do that. Now, having said that, we all know that they also passed Jim Crow laws immediately after that, which the U.S. Supreme Court said were all enforceable. We all know that many housing leases and deeds had restricted covenants that she's referred to, and the Supreme Court said they were all enforceable by law. And so we had things such as here in this area, places like Grosse Pointe, where you had restricted covenants that said you couldn't sell to anyone black, Greek, Italian, Jewish, Dearborn, all the sundown towns that we've got more than our share here in Michigan.
So what did they do? I mean, when they went to this, they just ignored the fair housing law, or they thought that there was a way to integrate them, or do you know what they did?
In 1866?
No, at the point where they were, fast forward, restrictive covenants in the 20th century that were being.
They said they were contractual laws, and so they enforced them because they were contracts and not civil rights. Okay. Okay, so they said these are contractual obligations. It has nothing to do with this civil rights law that's over here. This is a contractual, and it wasn't until the 1968 Fair Housing Amendments Act that they said, okay, we're going to have to somehow balance and merge these two conflicting goals. And so one of the things that the Civil Rights the Fair Housing Amendments Act did was to make it illegal to have restricted covenants. And so those things changed. But the law, the beauty of this particular law, as lawyers, this law gives plaintiffs far more power than almost any other law we have on the books. And the beauty of this law is that this year the U.S. Supreme Court, through the case that they recently upheld, upholds a legal doctrine that's been around for many, many decades, which is disparate impact. It was going to be at risk had they turned down or even weakened it, and it's a lot of probably the same kind of wheeling and dealing that happened in 1968. I'm sure, I can only imagine, was happening last year and this year, as they were talking about, although the Supreme Court is supposed to be above all of that, there was a lot of things going on, I'm sure, behind the scenes about the impact of having this law and this legal doctrine diminished. And I'm happy to announce, if you haven't already seen the news, because the same week that the Supreme Court upheld the concept of disparate impact is also the same week that they upheld same-sex marriage, and same-sex marriage got all the headlines and all the publicity, but for the community that works with us for fair housing, that was the case that we were most interested in, because that doctrine allows those of us who are in this field to do a lot of things that we cannot do in any other way.
What was the name of the case and what were the circumstances?
The case is in Texas, and what they basically said, and I can't tell you right off the top of my head the exact title, but the case involved the Public Housing Commission in the state of Texas. And again, remember, government was probably one of the largest architects of segregation, probably has as much to do with creating segregated communities as the Klan or anybody else. And so the public housing, which gets federal funds, had been limiting its new developments to predominantly minority communities. And a nonprofit group said, well, you know, what you're doing is perpetrating segregation. If you don't give federal dollars to developers who want to develop in predominantly white neighborhoods and can create affordable or low to moderate income housing in white neighborhoods, then you are limiting those people who, for either reasons of race or income, can't afford to live outside of a government subsidized building. You're limiting them to segregated housing. So they filed a lawsuit, and one of the ways to prove their point is that they use the doctrine of disparate impact, because they said housing studies have shown, thousands of studies have shown, where you live has a larger impact on where you go to school, what kind of education you have access to, where you're employed, what kind of jobs you have access to, how you can get to those jobs, transportation. And so they use disparate impact studies to show that people who live in this part of town and that part of town had access to opportunities that were different than the people who lived elsewhere. They couldn't say that you kept someone black or Hispanic from living in this particular housing, because that was a given. They hadn't given any federal dollars to create housing in those, but they wanted to talk about the impact. What was the result of the federal government's failure to do that? The case was against the state of Texas, but it should have been, or could have been, against the federal government itself, because Texas was simply getting federal dollars for home, for community block grants, for low-income housing tax credits. All of those are, in some form or fashion, federal dollars. But that doctrine has been upheld. We're happy. We can go on.
Do you know if that doctrine went over into other federal agencies? I asked that because I believe something like that is going on with the FTA now. I know people who were able to want to build on projects and do construction having to a certain time to submit bidding to show I say it wrong, disparate impact on projects coming up through the FTA. So it's funny that you mentioned, I don't know if because they upheld that or might this be something else?
Well, the case involved housing, but the concept, the legal concept goes across many, many areas, education, social service areas, mental health services. The concept is a strong concept. It's been used in many different types of legal disputes, but it's been used a lot in housing, and it was in danger. Had they not upheld it in this case, there were a lot of cases that exist today and are going to come up in the future that would have been weakened without it. So it's good news for those of us who are trying to advocate for the elimination of housing discrimination.
You previously mentioned that, I guess, the Fair Housing Center has an investigative arm in which it uses actors to go to different homes to see if there's discrimination happening. But what about on the enforcement end? When you find that there's discrimination happening in housing, how do you handle the enforcement? Do you have attorneys that you're working with that are already a part of the Fair Housing Center?
In your packet, in blue, is the qualifications for our cooperating attorneys. What we do, the law, because this 1968 law that was strengthened in 1988, the law allows a complainant a lot of options, more so than most other laws. And what Otto Hutzel talks about in this paper is that when they were trying to pass this law, they talked about should a complainant only have the option of going to HUD and having an administrative hearing as their only remedy if they felt that they were discriminated against. And there was a lot of argument, and what they decided is no, that shouldn't be the only option. Certainly people who have a complaint have the option of going to HUD. They have the option here in Michigan of going to the Michigan Department of Civil Rights. But they can hire one of you wonderful attorneys, gifted, smart, intelligent, and they can go straight to court, state or federal. They can do this simultaneously. Someone can walk into your office, and I hope that if someone does walk into your office and they say, I tried to purchase a house, and what they present to you might sound initially like a contract dispute. But what I'm hoping is after you thumb through our material, you'll be mindful of and start thinking, is there any fair housing element to this? There may be contract dispute. There may be, yeah.
So what's the damages? Is it specific performance, or is it monetary damages?
All of the above. The damages within a fair housing complaint lawsuit, because the way this is a beautiful law, because it's the way it's written, it allows the complainant, if it's at the administrative law level, or the plaintiff, if it's a lawsuit, it allows them to get actual damages. Certainly, if they tried to buy a house.
For the younger attorneys and even the older ones, in terms of attorney fees, is that going to motivate some of the folks?
I'm about to get to that. I'm going to get to that. They can get actual damages. They can get attorney fees. They can get punitive damages. Okay, so the law, this particular law allows for all of that. And what we do is if someone comes to us and we listen to their situation, we first tell them that they have options. And we ask them how would they like to proceed. Would you like to go to HUD? Would you like to, usually we tell them the 4 options. If they want an attorney, we have a small group of private practice attorneys that work with us. We're always looking for additional attorneys, and we will help train you in the law. You're not going to be out there, floating around without assistance. We have pleadings that we, have as examples that we've gathered over decades. We have more experienced attorneys that are more than happy to help work with you. We have a staff person that will work with you. So if you decide that you want to be a cooperating attorney, we will assist you. But what we do is we tell the person, here's our list of cooperating attorneys, and we usually encourage them to, call, have a conversation as they would any other litigation issue, and try to get the person that they feel most comfortable with. Sometimes we will shortcut that, to be honest with you. If the case looks like something that we know someone else has more expertise in, we might say, this particular case, we have attorney X, Y, and Z that's done a lot of work in that area, and might be your best fit, especially if it's a tricky set of issues. But for the most part, we try to just give them 3 choices, let them pick their own, and then we start working with that attorney. The cooperating attorney, we don't tell you how to practice the law. We tell you what your options are, and you come up with your own strategy. But, we've got cases active right now with our cooperating attorneys that have filed in federal court and